All right, we're going to be discussing the top 3 ways Utah landlords get sued and some of the things you can do to avoid them. In attendance on this webinar we've got real estate agents, real estate investors, self-managing landlords, and other rental owners, that hire out the property management. Even those that are wanting to get into real estate investing. Many of you are joining us on the web, or either on the web or on the phone. Either way, we welcome you. We expect this to be well worth your time. So I'm Nate Tu, president of Keyrenter Property Management, Salt Lake. Our team here helps investors find greater success through proven strategies to find, buy, sell, lease, and manage real estate investments. We offer full service solutions to those that currently own properties, and also turnkey solutions for those that are wanting to get into real estate investing. I'm going to introduce our guest in here just a moment. But with this webinar, I'd like to help set just a few expectations. First, we'd like to invite you to ask questions. We encourage Q&A throughout this webinar. We'd love to have that interaction, and being able to answer your questions will be important. And for the sake of everyone's sanity, you will be muted, but if you have a question, you're joining us through the webinar and not just calling in, you can ask a question via the chat box or by using the raise hand option, where we can then unmute you. We'll do our best to address your questions throughout the webinar. Secondly, we're planning on about 45 minutes for this webinar, give or take a little, depending on the amount of questions you ask. And if we have more questions, we'll go up until the top of the hour, of course. And lastly, if you're unable to attend the entire webinar, that's okay. It's being recorded. We'll make it available to those that are attending. So I'd like to introduce our guest today. I'm joined by Kirk Cullimore, Jr. of the law offices of Kirk A. Cullimore. And Kirk Cullimore, Jr. is a graduate of Brigham Young University and the University of Oklahoma School of Law. Before working at the law office of Kirk A. Cullimore, Kirk Jr. practiced in Oklahoma in the area of federal Indian law, including tribal business transactions, gaming law, organization, and development of tribal policies and procedures, and administrative law. His practice in Oklahoma also included areas of general business and contract law, landlord law, evictions, fair housing, homeowner association, and collections. Since being in Utah, Kirk's practice is focused on collections, landlord law, fair housing, and property management. Kirk currently serves as the Government Affairs Chair for the Utah Apartment Association. Welcome, Kirk. It's good to have you join us.
Thank you, Nate.
I've known you for probably going on 7-8 years now since you came from Oklahoma. Is that right?
That's right. Yep.
And we've been working with your law firm for years, ever since we actually started our business over a decade ago. And you've been instrumental in our ability to grow and scale and provide a great service to our investors, as we rely heavily on some of your guidance in different situations.
Thank you. I appreciate that. That's what we aim to do.
And I think with our discussion today, it's really top of mind for a lot of people, especially if they're landlording and they're self-managing on their own. What are some of the big pitfalls that they could potentially run into? What are the situations that they need to try and avoid, ultimately, as property managers? Because we know anyone who is landlording or managing that property is the property manager. So if you have an investor that hires a property management, well, that property manager is the landlord. They need to know this stuff. But if you're self-managing, what we're talking about today will be critical to make sure that you're not getting yourselves into trouble. Of course, there's more than just these 3 top points, but we can't cover them all in 45 minutes to an hour, of course. But let's jump in to number 1, Kirk. And of course, if I missed anything in the introduction, you want to go there and clarify some things, you'd like to share anything else about yourself or about what you guys do throughout the webinar, feel free to do that. And again, just a reminder, feel free to chat questions, raise your hand, and we'll get to those as best as we can. Let's jump right into it with number 1, which we have as issues with security deposits. I'll let you take that away, Kirk.
All right, thanks, Nate. Thanks for the introduction too. And let me preface this by saying that we're going to talk about issues where landlords find themselves getting sued. But despite following the law, despite doing everything per contract and dotting your I's and crossing your T's, you're still going to get sued sometimes. Landlords still get sued. And so not only is this preventing lawsuits, but it's also about having a good viable defense for when those lawsuits inevitably come sometimes. So the first issue is with security deposits, because at the end of most tenancies, whether that end was necessitated by an eviction or whether they skipped midstream or whether, they completed their lease term, gave proper notice and vacated, oftentimes there's going to be amounts due and owing, or there's amounts subtracted from the security deposit, and issues inevitably rise there. And so we see this a lot in our practice because we're asked to pursue collections for when tenants leave owing money. Obviously, you guys are very familiar with when tenants dispute your analysis of the security deposit disposition and, take issue with some of the charges you may have. And so this is a very common dispute, and unfortunately oftentimes rises to the level of litigation. So let's talk about the landlord's obligations when it comes to security deposits. First off, in the state of Utah, everybody is required to send out a security deposit disposition at the end of a tenancy. Sometimes this is called a move-out report, a final statement, whatever you call it. If there's a security deposit involved with the lease, then you must send out that itemization. When does the time frame begin to run? So Utah state law and most contracts state that you have to send it within 30 days after the tenancy. When is that? We generally advise our clients that is after you get possession of the premises. So if they skip and they turn in the keys midstream, when you get those keys, that's when the 30 days begins to run. If they gave you proper notice, once they turn in the keys, and if you evict them, once you've changed the locks, the 30 days begins to run. So the 30 days is you have to send out an itemization of how you use their security deposit and also send a refund of any amounts that are due to them, or let them know what amount is outstanding. Where do you send that to? We have to send that to the last known address. And so oftentimes that means we're sending it right back to the address, our address, or the address that they just left. And they may or may not get that. But the burden and the onus is on the tenant to either one, update the post office with their forwarding address, or even better, give it to you as the landlord. Let them, they should let you know where they're moving to so you can get that to them. The biggest dispute is they claim they never saw the security deposit disposition. And, 2 years later, when we're fighting about what may or may not be owed, their biggest complaint is, well, I never knew about this. And so just get in the habit of always sending it and then documenting where you sent it to and on what date you sent it to, because that's going to be your best defense. And under Utah state law, there's actually a law that says if you do not send them the security deposit disposition, you could be liable for additional damages. You could be liable to return back the whole security deposit and potentially owe them a penalty of $100 and attorney's fees. We changed that law about 2 years ago to where now for them to make use of that and to hold you liable for the fee and attorney's fees, they have to give you a 5-day notice saying that we don't think you complied with the law. And if you don't comply within 5 days, then we can bring lawsuit claiming that you're responsible for a refund of the full security deposit plus the $100 penalty plus attorney's fees.
Hey, Kirk, can I jump in real quick? So we've had tenants who, let's say, there was an issue with the mail or some situation where they didn't get a letter. We also email it so they know something's coming, but the law is it's got to be mailed. But we had tenant send us a letter or bring it in, basically saying, okay, it's been 32 days and we don't have our disposition of the deposit. So now you have to, according to state law, now you have to pay us the full deposit and the $100 fee and all that stuff. And I think there's a lot of tenants that understand it as being, okay, if we miss that 30-day mark or they didn't receive it, they're automatically entitled to the entire deposit and the fee. And so that grace period of 5 days where they give you notice as a landlord can be that trigger of saying, okay, well, maybe there's an issue with the mail. I know I sent it out, but okay, here's 5 days. I'm going to go ahead and send it so I'm in compliance with this notice and everything's okay. I think that was instrumental in making this process be fair and equitable.
Yeah, you're exactly right. And there's still a lot of misunderstanding about the law. And I hear that from tenants a lot. Hey, you didn't comply, didn't get it within 30 days. I'm entitled to everything. And that's just not the case. And even most attorneys out there representing tenants don't understand that still. And so, yeah, that grace period is key. As part of the notice, they have to let you know where they're at now. And so, again, that's going to be a viable defense. It may not necessarily prevent them from bringing a lawsuit or a meritless claim, but it's a nice cushion for landlords. Even if a tenant comes back to you 2 years after they vacate and say, you owe me my full security deposit because I didn't get anything, they still have to give you the 5-day notice at that point.
Let me ask another question here, and you guys feel free to chime in with questions if you'd like. This disposition, we've had tenants that have said, hey, your disposition is not adequate because you're not providing receipts from your contractors or invoices from your contractors, where we're not necessarily required to do that on the disposition. But what's your take on that, where you've seen people say hire an attorney, and the attorney pushes back saying, hey, you need to send all the original invoices and receipts and everything there. What's your advice there?
Yeah, you're exactly right, Nate. It's not required under the law, and so I wouldn't necessarily send that out until there is a dispute. But it's nice to have that as backup, because if they get an attorney involved, or if they take it to small claims court, or if they sue you, you're likely going to have to produce it at some point to substantiate those claims. And so how would that work if a landlord goes in there and does their own work on the property? So that's always a big question, and that's up for debate. When I've had to litigate this in district court and small claims court, usually if you can demonstrate that the need for whatever it is, the repair or the cleaning, if you can demonstrate that they left the rental unit in a state of disrepair and you had to expend efforts on it, you'll probably get some award for that. But if you do the work yourself, to the extent of how big that award is really comes into question at that point. And so I've had some judges tell me flat out that, you know what, this is your rental property and you put some sweat equity into this. And that's the cost of being a landlord sometimes. And so they'll figure out whatever formula they see just and fit at that time based on whatever pictures they have. But usually in my experience, I've found that you're not going to get much above $10 an hour as an owner working on your own premises, where if you had hired somebody to do it and they charged you $25 or $30 an hour, it's a little bit harder for a judge to diminish an actual invoice or actual receipt versus saying, yeah, I'm not going to give you, this is your own property, so I'll compensate you some, but I'm not going to give you, a market value or something like that.
That's interesting. Thank you.
So that's an issue, and that's where a lot of our clients will have move in, move out forms, right? And so you always want to have that to document the condition of the premises when they move in, and then compare that from when they move out. This is ideal that you have them go through it before and at the end of the tenancy. Obviously, that doesn't happen with evictions and different scenarios, but if you have that, that's nice. But a lot of our clients also have on that move in, move out form, or some form that they hand out contemporaneous with that, it will have an itemization of different charges that the tenant may be charged for various things not done. If we need to repaint, we charge you $150 per, for a 2-bedroom unit or something like that, or a whole home might be $500 or whatever. But if you have those pre-assigned charges and they sign off on that, then if you have to do that, oftentimes we can point to the court, to the trier of fact, and say, hey, they've already agreed to these specific charges. Now, one thing I find that my clients tend to rely on that too much, and they say, well, we had to clean, it's $150. Well, if you still have to substantiate that much cleaning was necessary. And so that's not the end of the story just because they signed off on a predetermined amount for particular damages or cleaning charges. You're still going to have to justify that it was necessary. So, but I like those for some charges where you're probably not going to hire a third-party contractor to come in and do that. To have some predetermined charges is oftentimes a good thing. You know, if you say just a general cleaning is $80 or whatever, great. That's easy to do. If you have a carpet cleaning charge that you have a predetermined amount, that makes it nice too, because you may have a contract, you know, a regular vendor that you use that comes in and does it at a set price, or you come in and do it with your own equipment, but it's nice to have that predetermined price for some things. But anything that's unusual or higher than normal, it's much better to have an invoice or a receipt versus saying you did it yourself and it cost $400.
Right.
Go ahead, Nate. Did I cut?
No. You're saying the one of the first issues is just not sending it out at all, and I think we covered that pretty well.
Yeah. So the next issue is, and we've kind of addressed this, but making sure that your charges are legitimate and that you can substantiate it. In today's day and age, it's crazy that we don't have pictures for all of this. I mean, that a picture says 1,000 words. That's absolutely true when it comes to court, small claims court or otherwise. If you have a picture of the before and after, that says it all. I win way more cases where you have actual photographic or video evidence of the damages. And then if you have receipts to support that, even better. But even when attorneys get involved or anything, if I send them a picture of a trashed place, there's not a lot they can say. You know, at that point, you're just negotiating what the settlement should be. And so that's always better than fighting it in front of the court. Yeah, so not returning it, and then disputes on the amount. And then, what was I going to say? So we got, make sure you have the documentation, make sure you can substantiate it. Oh, and then make sure it's reasonable. I have some clients that they'll do an itemization of what's owing, and they even have predetermined amounts for each thing, but they may have $15 to clean a toilet, $10 to clean a sink, $5 to sweep the floor, you know, and that's a little bit too much, because at the end of the day, sometimes I get a $2,500 cleaning charge, which, you know, you could hire 3 cleaners to come in and spend 8 hours on it, and you'd only pay them like $250. And so really scrutinize your own security deposit disposition and think, is this reasonable? Because the problem is the judge isn't just going to knock down a few of the unreasonable charges. It puts your whole security deposit disposition under a cloud of suspicion, and they start knocking down everything. And so that becomes problematic if you're unreasonable on any one particular charge. The other thing I was going to bring up is make sure that you appropriately prorate particular charges, like flooring. If you have to replace the carpet because they had animals that destroyed it, you've got to prorate it. And our general advice is that flooring is prorated on a 7-year scale, because the IRS has a 7-year depreciation schedule for carpet, for example. So if they've lived there for 3 years and the carpet was put in 2 years before they lived there, that's 5-year-old carpet. If you have to replace it because of them, you should probably only be charging them 2/7 of the replacement cost.
You know, I was going to add too, you know, HUD has a great depreciation schedule available that our team uses to kind of get an idea and an estimation of cost of the materials. Labor, of course, and you're probably about to say this, labor, of course, can be charged, because that's, you know, that's something that was, the need for the labor is created because of the issue.
Exactly.
One of the challenges that we've had is sometimes a client will say, you know, they put a little scratch in the front of the fridge. It's a stainless fridge. That scratch wasn't there when they moved in, so I get a brand new fridge.
Yeah.
or we have some scratches here on the hardwood floor. We have to replace everything here on the floor, and so when we talk about depreciated value as well as reasonable wear and tear, that all has to be taken into consideration.
That's a very valid point, and that comes up a lot. I mean, probably 5 times a year, I deal with single-family homes where the owner has an expectation that all of the hardwood flooring in the home has to be replaced because there are some significant scratches in one area, and you just can't fix that and not match the entire flooring throughout the house. And so now you have a $10,000 charge. And from the court's perspective, what they're going to say is, absolutely, that is not reasonable. And guess how many times I have these issues in big apartment communities? Never, because a unit that is designated to be a rental home is not going to have expensive hardwood flooring in there. And so and that's hard to understand when an owner converts his personal home or some other home that he buys into a rental unit, it takes on a whole new characteristic and a whole new purpose as far as the courts are concerned. When you're renting it out, it is not your home anymore. It's not your baby. It's a rental home at this point. And as a rental home, there's going to be reasonable wear and tear. And so the courts expect you to expect that, whether the owner plans on moving back in after their mission or whatever, it doesn't matter. For that time period, it was converted into a rental home, and it's not going to be treated like your baby, like your single family home, like your residence. And so that's something that's kind of hard to understand for some landlords sometimes. And you know what, a hardwood floor might get scratched in an area, and it's really going to be difficult to put a price tag on that to fix it to where that owner expects it should be.
If you don't mind, I'll jump in just one more time here on this topic. I think that every investor, every landlord, they want to have their properties kept up and maintained to a certain standard, so that they can see that their property is going to appreciate. If they end up liquidating that asset, they can get, for the most part, top dollar for that property. So I think it's a reasonable care and concern that a landlord would come in and say, you know what, I want to replace these floors, or I want these floors to get to be nice, but at the same time realizing that this is a business. This is treated as a business, and as long as we're treating it as an investment, where we're concerned about the cash flow or the cash on cash return, the rate of return, and ultimately, at the end of the day, having this investment perform for us, having that be the foundation of our motivation, rather than any emotional connection we might have with, whatever type of flooring or whatever things are in the home that might get, damaged over the course of time, which is reasonable to expect.
Yep.
Anything else with security deposits you wanted to go into before we went on to the number 2?
I don't think so. Just other than most of the time where I see lawsuits involving security deposits is a tenant, I should say against landlords, because we do it against tenants all the time in district court. But against landlords, this usually comes up in a small claims court. The good and bad thing about small claims court is it's resolved really fast. You get a hearing, you show up at that hearing, you have your opportunity to present all your evidence, and that's about it. Sometimes the bad thing is small claims courts are hit and miss. Like sometimes you get a really good judge, sometimes you get a judge that's just flying by the seat of his pants and just does whatever sounds good to him that day. And so you have to be ultra prepared. Small claims courts, even more than district courts and anywhere else, are going to hold you as the professional or as the landlord to a much higher standard than the tenant. And so you need to go over and beyond to justify and substantiate each of the claims on a security deposit disposition, particularly when it exceeds the security deposit. Because I don't care what court it is, anytime I've actually gone to a trial over a security deposit issue, the court or the judge will inevitably diminish the landlord's claim to some degree. That's just human nature. They want to split the baby, whether the law is on their side or not. They're trying to they're going to make you concede a little bit. And so the more you have, the less you're going to have to concede. And just know that going into this lawsuit, if you think the tenant owes you $2,000, the judge is looking to diminish that. It's very unlikely you're actually going to get all $2,000. So just having a realistic expectation of what's happening. And if you understand that, it may make sense a lot of times when a tenant contacts you and takes issue with that to negotiate a settlement with them at that time before, a judge or courts get involved. Say, you know what? Okay, I understand you dispute this. If you pay me $1,600 of the $2,000 right now, we'll call it good.
Yeah, that's a good point. And in the over a decade we've been doing this, we've never gone to court for a tenant who is coming back on a security deposit for a number of reasons. One, we have a lot of good documentation which can put it to bed early on. But then, if they want to file a claim, let's say that, they're upset about a cleaning charge, and they're really pushing it to go to court. They may be happy just selling for $100, and is it going to be worth going to court over something so frivolous like that? So pick your battles. Right. If we're talking thousands of dollars, of course, but pick your battles and weigh that out. Try to settle. I agree with Kirk 100% on that.
Okay.
All right. Number 2, alleged problems with the rental unit, fit premises issues.
So this has to do with the Utah Fit Premises Act, which gives the tenants an avenue to either withhold rent, to terminate the lease, or repair something and deduct it themselves and deduct it out of rent for the next month. There's 3 types of fit premises types issues under the law. The first is an emergency. An emergency type situation is something that could cause immediate risk of, to health or safety of the tenants. We're talking like exposed electrical wires, gas leaks, stuff like that. If you have issues like that, you have to address it within 24 hours. And I don't think there's any landlords that are not looking to address those. Any of these issues don't necessarily have to be resolved within the specific time frame. They just have to be addressed so it no longer poses a risk of health and safety. But then you also have to spell out what your plan is to fully resolve this. And so I don't see a lot of lawsuits over the emergency situations because they do get resolved. The next issue is habitability issues. And this is where a tenant is claiming that his premises is not safe to live in or habitable because he can't lock the door, or there's plumbing problems, or it doesn't get cool enough in the summer, or it doesn't get warm enough in the winter, or any number of issues like that. Those have to be addressed within 3 days. If they're not addressed within 3 days, and the tenant serves upon you proper notice, then they can elect one of those remedies, either to terminate the lease, to repair it themselves and deduct it, or to stop paying rent until you resolve it. The final issue is contractual issues, and you have 10 days to address that. Contractual issues, in my mind, mostly come back to appliance issues. Having your dishwasher broken does not necessarily make the place uninhabitable. However, if they signed a lease and there was a working dishwasher there, it's reasonable for them to expect that the landlord will maintain that dishwasher. All of these issues, they can only rely on the remedies provided or potentially sue you if they did not cause the problem. And so if they caused the problem, we're not talking about the Fit Premises Act anymore. Also, if they are not current on the rent, they cannot make use of the remedies. That's provided under the law. And so oftentimes where we hear this is where we've begun a lawsuit for non-payment of rent or some other issue, and then they allege there's something wrong with the premises. Well, that's too convenient of a defense. And so the legislature in their wisdom saw, hey, we're not going to allow that to be a defense to non-payment of rent. You have to be current on your obligations before you seek to enforce any of these remedies under the Utah Fit Premises Act. So really where you see these lawsuits is, for the most part, it's not the Keyrenters, it's not the property management companies of the world. it's the slumlords. And so this is trying to protect tenants against the slumlords. But with that said, it still does not necessarily mean, and like I said earlier, it doesn't mean you're immune from lawsuits just because you're doing what you're supposed to. And so the key again is documentation. If they bring an issue to you that sounds like this is a habitability issue, you will want to take that in writing, and then you will want to respond to them in writing and tell them what you've done to inspect the issue, what you've done to address the issue, and how you expect to fully resolve the issue. And if there is no legitimate issue, you need to put that in writing as well. Say, we've got your complaint or your notice about whatever. We've inspected. We have not found it to be an issue. If anything else arises, please let us know. Otherwise, we deem this matter resolved. Communication and documentation, that's going to be your best defense for these types of claims, because it shows that you're addressing it and shows that you're complying with the act and with the contract.
Kirk, one quick little mini story here. This past winter, we had a tenant whose heat went out. This is probably mid-December, so it's cold. It's cold. We had a relatively warm or a pretty warm winter, but in December it was pretty cold at the time, and so it was probably about 7, 8 at night, and our after-hours crew, they took the call and said, okay, we can have someone there at 11 o'clock, or it was like 10:30, 11 o'clock, because they had other jobs they had to take care of first. And he said, well, that's too late for me. I'm sorry. It'll have to wait. The next morning, he served us with this compliance notice that he printed off the state website, saying that we were out of compliance with the Fit Premises Law and the Fit Premises Act. And it was just so interesting that, okay, well, we tried to get out there that night, and it's just the next morning. And so there will be some residents. Yes, this is to protect residents from slumlords, right? We got to make sure we're taking care of things in a prompt manner. But there will be those tenants that, of course, they are on a separate pedestal, so to speak, that want to make sure that things are done according to their timeline and super, super quick. We had it resolved in less than 24 hours, but we got served literally the next morning. It was kind of funny, but we got it taken care of. I had a conversation with him and just made sure everything was okay, and it was. But you'll get some of those as well from time to time.
Yeah, and that's the beauty of this act, is just like we have to serve upon them a 3-day pay or vacate or comply or vacate, and we give them an opportunity to cure, they have to do the same. They don't just send you a text. They don't just put a maintenance request in your property management software. If they're legitimate about this, they have to serve a notice upon you and then give you an opportunity to cure. And so, and just being able to demonstrate the steps that you took towards resolving that problem is usually going to be defense enough.
Oh yeah. Yeah, but we've also heard of the stories, we've probably all heard of those, where the tenants, has a sewage backup in their basement, and then they can't get a hold of the landlord for 2-3 weeks because they're out traveling and they don't have a property manager in place, and they're trying to do it themselves, and they're not available, and it goes on and on and on, and that can be pretty dangerous. And that's those sort of situations, right, that Utah's trying to, get cleaned up and get taken care of.
Yep. And again, communication is key, because there may be legitimate times where you have a vendor, like let's say, it's about to get up to 100 degrees here, and the AC goes out, and, their rental unit is above 90 degrees. I mean, that's probably not going to be deemed reasonable. And, but you may not be able to get somebody there for 7 to 10 days. And so you want to be able to document what it is you're doing to help them. Maybe you go over there and provide fans or a window unit or anything like that, which, mind you, may or may not be necessary depending on the circumstances, but feel free to call us if you have any questions. But if you document, this is what we did, we scheduled it right away within the appropriate time frame, the vendor just couldn't get out for X amount of days, that's going to be enough, and you know what, sometimes stuff happens, and that's why we either strongly encourage or require renter's insurance for situations like that, because The courts will understand, whether tenants understand this or not, that stuff happens sometimes when in the places you're living, whether you own a home or whether you're renting a home. Stuff happens, and there's only so much any one person can do, and that's where insurance comes in where necessary, and where we take whatever measures we can and move as timely as possible, and that's all we can do.
Yeah, we have two of those situations going on right now where a tenant's going to be displaced because of a leak in a condo building that was from the upstairs unit above. We do not manage that unit. I believe an owner-occupant lives there. And, their renter's insurance is what would have to put them in a hotel for temporary displacement. As insurance is there to cover the damaged party, or they're insured, not necessarily the homeowner's insurance to cover the tenant. So that's a good point. Always require renter's insurance, and not just renter's insurance, but also landlord liability policy from the tenant that covers your property up to $100,000 or $100,000 minimum in the event that they cause damage.
Absolutely.
Good deal. Anything else with fit premises, or are you ready to move on?
If there's no questions, I'm ready to move on.
Yeah, we had someone's hand up for a minute, but it went back down. So if you do want to ask your questions, go right ahead, and we'll get some questions going here. All right, we'll go ahead and move on to number 3. This is issues with abandoned property.
So this is the area where I probably see the most lawsuits, and really where I see the most landlord exposure, is dealing with abandoned premises and abandoned property. So let's briefly review the laws first on abandoned premises. So when is it appropriate to deem a premises abandoned? There's 2 scenarios under the law. One is when rent is not paid, you inspect the unit and there's nothing in there. If there is no personal property remaining in the premises and rent is not paid, there is a presumption under the law that the place has been abandoned, and you can then deem it abandoned. The second scenario is rent has not been paid for at least 15 days because there is stuff in the property. So if you post a 3-day pay or vacate notice on the 5th and you don't hear anything from them and it's now the 8th, my office will usually advise, well, are you sure they're there before we file the eviction? No point in filing and wasting your time and money and filing an eviction if they've actually already vacated. So we'll advise you to at least look. If you look in there and there's stuff in there, okay, now we may be talking abandonment. So we would request that you email them, you text them, you call them, try to figure out where they are, what's going on, because you can only deem it abandoned if rent has not been paid for at least 15 days. So you're going to have to wait until the 15th, and you have no idea where they are. If you get a hold of them and they're in Florida and they're there for a funeral and they're not coming back for 3 more weeks, well, we probably still know where they are, and it's probably not appropriate to deem it abandoned. That doesn't mean we can't move forward with the eviction. It just means we can't deem it abandoned. If you find out that they got arrested and they're in prison, or wouldn't be in prison yet, if they're in jail, then we know where they are and we cannot deem it abandoned. So this is legitimately when we don't know where they are and rent has not been paid. I keep saying when rent has not been paid because it's key to know that if rent has been paid, it doesn't matter if the place is empty. It doesn't matter if we don't know where they are. If rent has been paid, the premises is not abandoned. And I highlight this because that's where a couple of the lawsuits that I've dealt with over the past couple of years have arisen. Maybe it's the end of a lease term and the tenant tells you or the manager that they intend to vacate by the 20th. And you say, great, that gives me a few days to turn it before the end of your lease term, and maybe I can get it re-rented quicker. Or maybe they even negotiate to get out in the middle of their lease, and you're saying, you know what, if you get out by this date, that'll help me because I can get it re-rented to mitigate your damages, so you won't be liable for the rest of the lease if I get somebody in there. And so they tell you they're going to be out on the 20th, but they've already paid for that month. And so you send somebody over on the 21st to start turning the unit. And that person goes in there and mostly everything's gone, but there's a few things left in there. You need to turn around and leave because inevitably they're going to claim that you messed with their stuff, that you took their stuff, or that some stuff is missing. And because rent has been paid, that place is not abandoned. We don't have a right to that premises other than what we usually do as a management company to inspect and whatnot. And so that's where I've had to deal with a couple lawsuits, is maintenance guys or management going in and starting to turn a unit when there's a few things still in there, because they assume, maybe even rightly so by communication, that the tenants have intended to vacate and there's stuff in there. So be careful on that. For one example is I had that very scenario happen where a maintenance guy went in, everything was out of the unit except for a bag of clothes that was on a balcony. There was a 2-drawer plastic filing cabinet in the front room that was full of different papers. And then there was a curio cabinet, a jewelry cabinet in the back master bedroom closet, and a shotgun. That's all that was in there. Although I wouldn't expect somebody to abandon a shotgun, everything else you could have looked at and thought, well, maybe they abandoned it. And so maintenance started working on the premises, started painting stuff. Didn't really report anything to management. Did about an hour and a half work that day, left, came back the next day to finish up some patchwork and some painting. And the shotgun was gone. The cabinet, the jewelry cabinet, was in the front room now next to the plastic filing cabinet. And the bag of clothes was still on the balcony. So now maintenance guy thinks, oh, okay, well, I guess they really have abandoned because they came in and took what they wanted, and that's that. And so the jewelry cabinet got knocked over. When it got knocked over, for whatever reason, maintenance guy kicked it and broke it. He threw the bag of clothes away off the balcony. And this was still all before the end of the month, so rent had still been paid. A month later, the tenants decided to sue the management company and said, you compromised our identities because in that filing cabinet was our social security numbers, our birth certificates, all that sort of stuff, which we had no idea. My client had no idea. They said that they stole jewelry out of the jewelry case, which is not true, but they did damage the jewelry case. And they said that they threw away hundreds of dollars of clothes. And so they were now getting sued for $5,000. And they got sued in small claims court. And like I mentioned about small claims court earlier, sometimes you don't know what's going to happen. And they ended up losing about $3,500. And really the basis for the court's decision was, yeah, you're a professional management company. You know what the laws are. You should have known better. It wasn't even necessarily a finding that there was $3,500 of damages. It's just they alleged $5,000 of damages. You guys screwed up. I'm going to give them $3,500. So that's the risk. Here's the bright side of the story: is we appealed that to the district court, and at the end of the day, they ended up only winning about $250 for the broken cabinet and the clothes that were thrown away. But how much time and hundreds of dollars of legal fees did it take to get to that point? And so that's one of the risks. So I've talked about the two scenarios under state law where we can presume a place abandoned. A new law just went into effect in Utah to where we get more than just a presumption of abandonment. We can legally deem it abandoned if we've met those two scenarios, and then we post a 24-hour notice on the premises, and then that puts a burden on the tenant to contact management or the landlord if it is not abandoned. And if it is not abandoned, then we let them back in. But if it is abandoned and we've posted that notice, now we get more than just the presumption of abandonment. It's legally deemed abandoned. And so there's just that extra safeguard in the law now that I would recommend that you comply with. That literally just went into effect yesterday. And so we will be publishing forms about that on our website for management companies and landlords to use. Once a place is deemed abandoned, if there's personal property in there, you still have an obligation to that personal property. You need to post and mail a notice of abandoned property at that point. Once you've secured the premises, deem the premises abandoned, and there's still stuff in there. If you post and mail a notice of abandoned property, you have the obligation to store that stuff for at least 15 days. And it needs to be secure. If anything happens to that property within 15 days, excepting criminal activity, the landlord is liable for that. And there's 3 exceptions to the 15 days as well. If they give you notice of a death, if they give you notice of an extended hospitalization, or that there's allegations of domestic violence, then you have to hang on to that property for 30 days, and you'll be liable for it for the 30 days. When there's personal property in there, you've changed the locks, and now you've posted and mailed the notice, take pictures of that, because you are responsible. It's not uncommon for shady tenants to claim my heirloom went missing or this and that went missing. And we may say that was never in there, but if you can take pictures of what is there, even just general pictures around the rooms and stuff, you can say, we didn't disturb this. This is all it was. You don't necessarily have to store the stuff in the same place it was for 15 days. You can move it if you're trying to turn the unit or get things going. But in the event that you do move it and put it in storage, then I would document exactly what you moved and take pictures again. And again, you don't have to be super specific. You don't have to say one yellow shirt, one white shirt. You can just say bag of clothes or something like that. But definitely document if you decide to move it, and then still keep it secure for 15 days.
You know, Kirk, just to chime in real quick, one thing that always surprises me is even when it's not, say, an eviction or an abandonment situation, and tenants are just moving out, just a routine move out. They put in their notice, they're moving out. It's amazing how many tenants just leave so much stuff behind, because, you know, rather than taking a DI run or, you know, Salvation Army run or something like that for some of the stuff that they don't want anymore, they'll just leave it in the house because it's easier for them. Well, yes, they're going to pay for it, but we have to store that or do something with it unless we have them sign off on it being okay to do that. So what we've started doing is when they turn in keys, we require that they turn in a key receipt where they sign off and say, any personal belongings, anything left in the house, I'm deeming it, you know, okay to dispose of. You know, I have no personal interest in it, whatever it says. There's some legalese in there, so that we can then go to the property, and if it's full of stuff, we're okay. And that's a conversation you and I had. Or anyone on this webinar, if they have something like that they have the tenant sign after they move out and they're giving up possession, do you think most courts would say that's, you know, we're going to honor that?
Yeah, I like that process, that procedure, and I would recommend that. You know, I haven't litigated your form specifically, thank heavens for you. But yes, I've seen where even a text message or an email where it says, yeah, I'm gone, do whatever you want with the stuff in there. You get something like that in writing, particularly if they sign it on a form that you provided them. That's pretty solid defense if they come back and try to claim, you know, that something was disposed of that shouldn't be.
Because we have had tenants in the past that moved out and said, yeah, I'm totally out, you know, it's all good. And we go in and there's quite a bit of stuff, and then we can't get in touch with them. And there's always this fear, oh my goodness, they could come back and say that they left their, you know, whatever it is, and we could have an issue. So we got to store it in the garage, or we got to store it in the facility, wait the 15 days, sometimes 30 days if requested. And what a hassle. So we've started doing that. It's helped a lot.
Yeah. When you can't get a hold of them, then you've got to follow the procedure. And I have defended landlords in a few scenarios where they did follow the procedures, but still the tenant decided to sue them and claim this or that. And when we said, you know what, they left, we posted and mailed the notice of abandoned property. We didn't hear from them for more than 15 days. And in fact, we tried to reach out to them to no avail. And then we disposed of it after. And here's what we did with this property. We took it to the DI. Here's what we did with this. We trashed it. That's it. The law's pretty clear at that point. And the landlords have not been held liable under those circumstances. So I would note this when it comes to abandoned property, though. If we're talking about abandoned property after an eviction, treat that scenario a little bit differently, because we've locked them out. And even though the 15 days may begin to run the time we lock them out, we post and mail that notice of abandoned property. They may be in contact with my office or another attorney that you may be using, or the management company, and we may be holding some of their stuff as leverage to get them to resolve the case or to at least set up payment plans. And so my thought is, if we didn't even give them reasonable access to it for like 7 or 8 days because we were trying to negotiate with them, then, should that count towards the 15 days? Under the law, yes. As far as what the equity in that and the reasonableness and fairness that a judge may look at, they may not count that. They may say, yeah, but they didn't really have access to it for 7 or 8 days. And so we ask on any evictions that we did, even once the 15 days has run, that you talk to my office and clear it before you throw away anything, because that's where you really can get yourself into trouble, is throwing away stuff on the 16th day when we've been in communications and trying to negotiate with them for the full 15 days. With that said, we understand how important it is for you to turn the unit, to get their stuff out of there. And so we're not intentionally trying to delay things, and we would, we'll let them back in there sooner if that's what you want to do. But just know that we're using that time, and it's not uncommon to use that time to try to negotiate a settlement with them and get money for our client.
Great. Anything else with abandoned property you think would be valuable to share before we wrap up?
Again, just make sure you know the law and know that you stick to it, because as landlords, you're held to a higher standard. You've got a higher level and duty of care. And so, knowing the laws, knowing that you've complied with the laws will protect you.
Very good. So let's open it up again. Anyone have any final questions or any thoughts or any scenarios that you'd like to run by Kirk here? I mean, we've got him held captive here, and we can get his knowledge to shed some light on anything you might be going through. All right, we've got Sandy Stewart, who I'm going to unmute here. Go ahead, Sandy. Let's see. Let's see if I can figure this thing out here. Sandy, can you? All right, are you there, Sandy? All right. Can't hear Sandy.
Maybe she can type it in.
Yeah, maybe you can chat it in there through the chat feature. All right. We've got another one here, Ember Davis. All right, Ember, are you there?
I am.
Great. Welcome.
Thank you. Thanks for doing this. So going back to that first one, I came in a little bit late, and I apologize, but you're talking sort of about the contractors and how it's sort of best to, if you're doing any repairs on a property, to basically hire it out. When it comes down to that cleaning, is that sort of the same thing? You were talking about how, putting prices on that cleaning amount, if you have a cleaning deposit, to be able to show, hey, I hired contracted cleaning company and it was $200. Is that sort of the same principle with cleaning as it is with like repairs?
Yeah, absolutely. If I have an invoice from a cleaning company that says $200, it's harder for the court to look at that and say, no, I'm only going to give you $100, as compared to when all I have is a ledger amount and the owner themselves attributed $200 of cost to their cleaning. The judge is going to diminish. They just are. It just happens. And so, yeah, an invoice is better. And mind you, I'm just telling you what I see in court. That may not be best business practice for you. It may be worth charging $200 of your own time to do it. And if somebody contests it, just being agreeable and say, fine, I'll only charge you $100, or realizing that if you get to court, that may get diminished. So long as you understand that, I'm not telling you need to hire a cleaner each time. I'm just trying to point out the realities of when it gets to court, what is more acceptable than others.
Gotcha. Cool.
All right. Thanks, Ember. Sandy, are you able to chime in here? You still have your hand up there. I want to make sure we can get your question. Okay. We've got a question here from Alan. He's asking, oh, sorry, he made a comment. He was going to be sharing this or watching this later. He missed a part of it. So any other questions here for Kirk before we wrap up? All right, well, I'd like to, of course, thank Kirk Cullimore, Jr. for joining us. And thank you, Kirk. This has been very informative, very helpful.
Thanks for having me. Happy to do it.
This webinar is recorded. Again, we're going to make it available to all those who have registered today. And of course, as always, we wish you all the best in your investment endeavors. And if you have any questions for myself, feel free to reach out. If you would like to get in touch with Kirk Cullimore, Jr., reach out to me. We'll see if we can make his contact information available for you. I don't have it here on the slide. Is that something that you would mind sharing, Kirk, or would you prefer have them go through us for that?
No, absolutely. You can find us on the web at cullimorelaw.com, or you can call us at 801-571-6611, or email me at kirkjr@cullimore.net. Great.
Well, thanks again, and best of luck to all you guys, and we'll see you next time.
All right. Thanks, Nate.
Okay, take care.
Everybody.